are seats available at the table if you'd sit, please.
Hello.
Well, good evening, everybody. Welcome to this side event sponsored by France and Senegal and organised by the International Criminal Court Bar Association. As you know, the ICCBA represents not just those who defend people before the International Criminal Court, but also those who represent victims, and its membership embraces members of staff within OPCV and OPCD as well. It was a considered decision this year to put on an event that was specifically aimed at the rights of detainees, because it was felt that the section of our membership which represents victims is represented well enough at side events during the ASP, and that the voice of the defence is quiet and getting quieter. And I need say no more than point to the publication yesterday of the list of independent experts that the ICC has decided will assist it in revising its structures in the future. And those experts number the following: 3 retired judges, a recently appointed judge at the STL, where of course they don't have accused, a judge at the Specialist Chambers of Kosovo, which may or may not be functional at some stage in the future, 3 prosecutors, a UN rapporteur, and a counter-terrorist operative. Not one person who's ever had a client amongst that lot. Not one person who's ever had to visit somebody in the detention centre. And not one person who's ever had to work under a legal aid scheme. It is disappointing to learn that the court does not feel that the defence bar is a useful resource for it to consult in deciding how better to function. But there it is. It's not just disappointing, it's foolish. And so tonight we're going to offer some great expertise, and this is a sparkling panel I'll introduce in due course, but I introduce them to you in the expectation that we are barking at the moon and that nobody really wants to listen to defence lawyers. Anyway, as I say, we are very, very, very grateful for the sponsorship of France and Senegal in putting on this event. And before I introduce the topics to you, I'd invite the representative of the Legal Affairs Director to the International Criminal Justice of the French Government, Marie-Renée Pella, to say a few words of introduction.
Thank you. Thanks a lot. Thanks a lot for being here. Well, it's quite late now, so I'll be quite short. France is very, very pleased to co-host this side event, and I have to say that we also have co-hosted another side event today about the respect of plurilingualism inside the ICC, so if I may, it will be quite important for me to express myself in French, so I hope everybody will be able to understand. En tant que co-facilitateur avec le Sénégal sur la coopération, la France est donc heureuse de coparrainer cet événement parallèle organisé par l'association du bureau de la CPI sur le droit des détenus devant la CPI et surtout sur leur mise en œuvre effective. Le règlement de la Cour, dans sa norme 91, dispose que toute personne détenue est traitée avec humanité et dans le respect de la dignité inhérente à la personne humaine. Ce droit est donc un droit fondamental, à La Haye comme partout ailleurs, mais à la CPI, sa mise en œuvre relève d'un fonds d'affectation spéciale qui est alimenté par les contributions volontaires des États. Et il semble peut-être que les États parties ne soient pas suffisamment sensibilisés à cette problématique Problématique d'autant plus importante qu'on le sait, la durée des détentions provisoires est particulièrement longue et peut avoir également des répercussions, ne serait-ce qu'en termes de future réinsertion et de préparation à cette réinsertion. Il y a donc de toute évidence une réflexion à mener afin d'améliorer la situation actuelle et d'envisager des pistes pour pouvoir, comme pour les victimes, imaginer que les droits des détenus soient pleinement intégrés aux objectifs stratégiques de la Cour. Et je suis sûre que les excellents panélistes que l'Association pour le barreau de la CPI a réunis ce soir vont utilement contribuer à cette sensibilisation aux droits des détenus. Je vous remercie.
Thank you. Delay is the scourge of proceedings at the International Criminal Court. It doesn't quite hold the world record. I think the world record is held by the case of Neeram Sahuko et al. At the ICTR. I managed to say that without falling over it. In that case, the accused were variously arrested between 1995 and 1998. The trial began in 2001 and finished in 2011, and the appeals were finally concluded in 2015, by which time one of the accused had been in custody for 20 years. Thank God none of them were found not guilty. The ICC hasn't been quite so lucky. Messrs Blegudet, Bagbo and Bemba, between them, spent 27 years in custody. And as things currently stand, none of them is guilty of the crimes for which they were originally arrested. Our first speaker is Milene Dimitri. And Milene represents Mr. Yekatom, who's in the pre-trial phase at the moment. He was arrested over a year ago. He's had no access to his family, either in person or realistically through communications. And Milene's going to explain some of the difficulties, the causes that have arisen in that case. Thank you, Milene.
Thank you, Peter. Avant de commencer, je voudrais également remercier la France et le Sénégal d'avoir accepté de parrainer cet événement parallèle. Je vais maintenant passer en anglais. When the subject of detention conditions is raised, it often triggers dismissive judgment and comments. I hear people saying that, what are the detainees complaining about? They're living a life in a 5-star prison. I often wonder, why being so judgmental towards detainees? Are we letting the presumption of innocence slip away? Do we consider that they deserve less because they are prosecuted? Are they presumed less innocent simply because they're facing serious charges before the International Court? When we look at their detention conditions, and more specifically, the restrictions on their telephone communications and non-privileged visits, it seems as if they lost their presumption of innocence and basic human rights. The subject I'm addressing today is not about the detention conditions in general, but more specifically about the restrictions on contacts imposed on some of the detainees currently held at the detention center. It's not widely disseminated that detainees currently held at the detention center of the International Court are not free to call their family members close relatives as often as they want. Those decisions imposing upon them such restrictions are not easily found in the court's case law, as most of the decisions and filings are ex parte. Only a few are available. I will therefore try to use the material publicly available to share with you the solitude the detainees, who are human beings, are facing as a consequence of the case law on contact restrictions. Regulation of the court, specifically Regulation 101, allows the prosecution to request the chamber to prohibit, regulate, or set conditions for contact between a detained person and his non-privileged contacts, if the prosecution has reasonable grounds to believe that such contact could prejudice or otherwise affect the outcome of the proceedings against a detained person or any other investigation. In other words, when the court transfers an individual and keeps him in detention, not only is he brought outside of his country of residence, away from his family and relatives, but the prosecution, with leave of the chamber, can request a prohibition of telephone contacts and visits with his family and relatives. In my view, prohibition of contact imposed on a prisoner is somehow a breach of the presumption of innocence. When such prohibition is imposed upon arrival of the individual at the detention center, the breach of the presumption of innocence is even greater. Indeed, there are some cases where the prohibition on contact was imposed by pretrial chambers upon request from the prosecution prior to the arrival of the individual at the detention center. In such a case, the message that is portrayed is not only are we suspecting you of having committed crimes, but we believe you could prejudice or otherwise affect the outcome of the proceedings or the investigations. So we will restrict your contacts and actively monitor everything you say to your family members on the phone because we don't trust you. When the prosecution argues that without an active monitoring of all detainees' phone calls to a family member, it could allow them to reach, intimidate, or harm potential witnesses, their families or other individuals cooperating with the court, it's a breach of the presumption of innocence, which is more often than not based on pure speculation. The message from the prosecution is basically, not only do we believe that you're guilty, but you're so guilty that you will do anything to hamper our investigation if we don't limit your telephone contacts and monitor them. When a request to impose contact restriction is made prior to the arrival of the detained person at the detention center, the request is not based on this individual's behavior at the detention center. It's not based on what he may have said over the phone or what he may have attempted to say since the restrictions are imposed prior to his arrival. The meaning of having substantial grounds to believe that the detained individual could prejudice or otherwise affect the outcome of the proceedings or the investigations is therefore based on pure speculation, not concrete information. Such decisions create an impression of unfairness from the detainee point of view. While at the early stage of his detention, the detainee is yet only a suspect, imposing him a restriction on contact with his family sends a message of mistrust. He is already being judged as someone who's not only considered a suspect, but someone that is so likely to be guilty that there are grounds to believe he will harm the witnesses or the investigation. In addition, in some cases, the grounds used to impose and maintain restriction on his contacts are out of the detainee's control. The prosecution will argue volatile security situation in the situation country, alleged support among the various groups in the situation country, government position held by certain groups, vulnerability of potential witnesses and victims. All these factors are outside and beyond the control of the person detained. How can the detainee ask for more contacts with his family members when the volatile security has no hope to improve anytime soon in the situation country? It's out of his control, especially when he's locked up thousands of miles away from the situation country. The factors used to justify reasonable grounds to believe seem to be completely independent from the will or behavior of the detained person. When one looks closely at those factors, the impression is that restriction on contacts recently became the rule and not the exception, and the burden has shifted. It nevertheless remains difficult to demonstrate, as most of the decisions are not publicly available. For this very reason, transparency of the case law is important to demonstrate that this rule is no longer applied as an exception, especially given the recent decision in Taganda, whereby the Chamber stated that the imposition of restrictions, including increased monitoring on a detained person's contact, constitutes the exception and not the rule. Given the lack of accessibility to the various decisions on this subject, it's quite a challenge for a defense counsel to attempt any argument that there is an inconsistency across the case law on how and what factors should be considered in the assessment of what constitutes reasonable grounds to believe, pursuant to Regulation 101. It's quite a challenge for any defense team to demonstrate that the arguments used to impose restrictions do not raise serious concerns, have nothing to do with the detainee's conduct, and therefore do not warrant what should be an exception, imposition of telephone contacts restriction. Restrictions now became the rule rather than the exception, but it is impossible to argue and demonstrate across the board given the lack of transparency of the decisions on the subject. It's also impossible for a detainee to attempt to reverse a decision limiting his contact with his family members freely. There are indeed several ways to reverse or challenge contact restrictions, but they are all almost impossible to achieve. There's, for example, requesting the pretrial chamber to vary the measures and increase the weekly number of contacts with family members and relatives a detainee is allowed to have. We could also request to leave to appeal or request for reconsideration of the original decision imposing restrictions on contact. But all three measures became impossible recently. While some detainees have undergone active monitoring for over a year, with registry reports noting that after listening to the conversation, there are no breach or attempt to affect the investigations or reach out to witnesses, pretrial chambers have refused to even consider varying the measures imposed, as it would be too burdensome for the detention center. Indeed, in view of the need to actively monitor the detainee telephone communication and prepare translation for what is being said on the phone, any increase of telephone contacts to a merely few hours a week would be too burdensome for the institution. The cost of actively listening to a detainee's telephone contacts or person contact with his family is high. It requires an interpreter who listens and interprets the entire conversation the detainee is having with his relative. On that basis alone, some chambers have refused to vary their decision imposing the restriction and denied any request to increase the amount of time a detainee is allowed to call his family and relatives. The cost for the institution supersedes the rights of our clients. Instead, some chambers have observed that the detainee may request his defense counsel to assist him in being additionally informed of the well-being of persons close to the detainee. The court's resources are not only used to actively monitor someone upon his arrival, but we're now asking the defense counsel to be the channel of communication between the detainee and his family members in order to keep him informed of their well-being. Counsels cannot maintain family contacts for their clients. The international instruments makes it clear that contact with family is a right, not a privilege to be earned. Asking your counsel to see how your children are doing and how your wife is feeling cannot and should not be used to supplement the right to contact with family. Unfortunately, the cost of active monitoring every private phone call and the presence of counsel are used to deny any increase in the number of allowed calls. Varying the measures imposed by chambers is therefore fantasy. Although decisions pursuant to Regulation 101 underscore that restrictions on contact and communications under the court's statutory framework must be reassessed in light of concrete, specific, and up-to-date information, the pretrial chambers in some cases refuse to reconsider on the ground that pretrial chambers have repeatedly held that the instruments governing the court's procedure make no provision for such a broad remedy as an unqualified motion for reconsideration, and that the review of judicial decisions can only be requested on the basis of mechanisms specified in the statute and the rules. So the second option mentioned earlier, reconsideration, also became impossible to achieve. Finally, although some might suggest an interlocutory appeal, unfortunately, chambers are systematically denying any leave to appeal on this issue on the ground that it's not an appealable issue, thereby closing the door to the third mechanism that gave hope to a detainee attempting to increase contacts with his close relatives. This, I hope, gave you a brief overview of how some of our clients live in solitude. Not only are they locked up thousands of miles away from their home, they cannot talk to their relatives as they wish, and when they do, someone is listening to their conversation and interpreting every word. They lost their dignity. They don't have privacy. Although since their arrest, all they can think of is how their family is surviving without them as the primary source of income, they cannot be informed of the well-being of their children and wife every day. When one of their family members passes away, they have to wait for their scheduled phone call to grieve with their relative over the phone. Again, with someone listening and interpreting every word. Try to imagine 1 second how you would feel having someone to listen to every word and interpreting every sentence you exchange with your wife or husband or child. While this measure is affecting the well-being of the detainees at the detention center, who are unable to freely call their relative and family members and inquire about their well-being, it's exacerbated by the temporary suspension of the funded family visits by the court, which is the subject of my esteemed colleague, Marie-Hélène Trou.
Before we pass on, Mylène, I wonder whether you would just put a little bit of flesh on the bones by telling us something of Mr. Yekaton's family circumstances and the concrete restrictions on his ability to communicate.
I can't talk about, unfortunately, I can't talk about the concrete restrictions imposed because, as I said, there's a lack of transparency. The decisions are confidential and ex parte, but what I can say is that Mr. Yekaton arrived at the court, at the seat of the court over a year ago. He has 11 children, 2 wives. One of his son was born 1 month after his arrival at the seat of the court. He never held him in his arms, and it's very difficult to communicate with his family. And on top of that, because the trust fund has been, because the funded visit have been suspended, he never held his son in his arms.
Next up is Marie-Hélène Trou. She's counsel for Mr. Al-Hassan, and as Mylène has neatly segued into her presentation, she's going to tell you about the difficulties with family visits at the detention center.
Thank you, Peter. Je voudrais à mon tour remercier la France et le Sénégal d'avoir accepté de parrainer notre événement. C'est très apprécié. Je voudrais aussi vous remercier, Madame la représentante de la France, pour les propos que vous avez tenus tout à l'heure. Je comprends que le fonds pour les visites familiales a été abordé aujourd'hui et que les États, peu à peu, comprennent mieux l'importance de contribuer. Et je suis très reconnaissante de ce que vous avez dit tout à l'heure. Malheureusement, je vais continuer en anglais, mais si jamais il y avait des questions en français plus tard, ça me fera plaisir de répondre en français. First of all, while I was thanking friends in Senegal, the second thank you I want to give is to you for attending this event. Defense events are not necessarily the most popular. Defendants are not terribly popular either, and we're aware of that, and we're fighting against the preconception that defendants are not necessarily worth of our time, of our money, of our care. And we're very much of the opposite opinion. So I apologize in advance for those of you, but I don't think there's a lot of you, who were at last night's event on the trust fund family visits. We had an event in another room over there, which was frankly very poorly attended. So please don't leave. No problem. And that's unfortunate because the issue of the family trust fund is a big one. As the defense counsel, we are dealing with this almost on a daily basis, and it's been months. And although last night we were told that donations had been promised from two states, the Netherlands and Germany, it appears, and we've learned only later, that the donations are relatively small and that basically we're not going to go very far with them. So the problem remains whole. So as Milan explained, detention is not an easy thing for anyone. No matter what you might think these men have done or might have done, they are presumed innocent, and they are under very heavy monitoring measures. They're restricted on every level. It's not an easy thing to bear. And they have families. They have loved ones. Milan just explained the family situation of Mr. Yekatom. My client, Mr. Alassane, is in a similar situation. He also has a child he has never met. He's, young children, young wives, a family that he cannot take care of and that he cannot see. So the question, counsel, when will I be able to see my family, is one that I hear all the time. I hear it regularly. And it's funny because last night I was at this event, and this morning I went to the detention center and I met my client, and I told him, maybe there's a bit of progress. There was this event last night. We talked about it. We're trying to raise awareness, raise funds, hopefully. But I can't promise him that he's going to see his family anytime soon, because he's not the only one. There's 5 detainees. And at the moment, we have no good answer to the question, when will I next be able to see my family? Because in the last few months, visits have been systematically denied because of the lack of funds. This year, in 2019, out of 5 detainees, and I'm not counting Mr. Bagbo and Legude because they left in February, so 5 current detainees, only 1 has received a funded family visit. 4 detainees have initiated legal proceedings over this. In the way that it normally works, you first do a complaint to the commanding officer, Mr. Craig, and then you can appeal to the registrar, and then you can appeal to the presidency. The best case is actually Milan's case, because they managed to file an appeal to the presidency that is public, and I would encourage you to read it because it is giving you a really good view into the real human drama behind this situation, the lack of funds. That Mr. Yekatom was hoping that he could receive visits of his children for Christmas, and it's been denied and denied and denied. And remains to be seen whether the small amounts that were promised yesterday will arrive on time or will be sufficient for Mr. Yekatom to see his children this year. Chances are probably not. And so the waiting is open-ended. It's an indefinite waiting period. In addition to rejecting visits, I know at least 2 detainees who have also been refused resources to help their families get their identity cards and passports in provision for a future visit. These are also steps that are important because not all family members have passports or have ID cards. And a lot of them are in very remote areas, so getting those papers mean that they need to travel. They need to pay a lot of money. They're indigent. They cannot afford it. So the court has to offer support, logistical support and financial support. But as things are now, it also has been denied for the lack of funds, which means that when funds occur, it'll take all that time to first get the papers and then get the visit. So we're months away from all of this happening. So as a defense counsel, the situation is quite difficult to explain to your client because the court has recognized the right of detained persons to funded family visit. it is not even in question. It's been recognized in Rougelot in 2009, reiterated in another case in 2016. This is a fundamental human right. Presidency said so. Nobody's disputing this. What we're disputing is how effective this right is. And at the moment, it is not effective at all. It means nothing to my client when I tell him you have a right to maintain family links with your family and receive funded family visits if I cannot deliver on this right. These are just words for him. And the impact is crushing. It is actually devastating. As Milan said, they can only speak to their families once, twice a week for a very short period. All their conversations are listened to. These are broken families. I mean, we are victimizing not only the detainee who cannot maintain this vital link with his loved ones, but also his children, his wives, his parents. All of these people are basically suffering from the current situation with the lack of fund in the trust fund. And of course, after the decision in Rougelot in 2009, they decided to create the trust fund for family visits. That was in 2011, I believe. And states, and you know, last night Mr. Dubuisson explained why that happened, but I'm sorry, I'm not calling you out. But he explained that, you know, there was discussions and they decided to go for voluntary donations, which is a choice that they made for various reasons. For me, my educated guess is they made that reasons because funding family visits is an unpopular issue. It is not popular, as I was saying earlier, to give money for defendants. And states do not want to be coerced. They don't want to have to give money for defendants for an unpopular cause. But popular or not, we have to respect fundamental rights, and we have to give ourselves the means to respect those rights. Otherwise, it's absolutely meaningless. And it's unfortunate that once again, after 25 years of this international criminal law business in The Hague, defendants' rights are still an afterthought. It's never a priority. We're not investing in that because somehow we're always left on the side. We're left behind. It's really problematic. The ICC has a duty of care to the detainees. It brings thousands of kilometers away from their home. The ICC has to be given the means to respect and implement that duty of care. There's no other solution. And you know, the presidency found that there is a positive obligation upon the court to render the right to family visits effective by funding such visits. So as the way that things are now, this right is not effective. The ICC is not able to implement its obligation towards detainees. And I believe that the trust fund has to be rethought. They have to rethink the whole process. At this stage, only 5 states parties have contributed to the family trust fund. 5 out of more than 120 states. It's outrageous. I'm sorry, maybe I'm being a bit too blunt, but it makes no sense that only 5 states accept to fund these issues. There needs to be more involvement, more responsibility from other states' parties. What was I say now? Yeah, especially in a court that has a budget of millions of euros. A family visit, we're talking peanuts. It's nothing. So really, I mean, it's not nothing. It's a few $1,000s, but you know, it's not that much in the grand scheme of things when you think about the budget of this place and you know, budget of individual states. So I think that states should really be called upon to make more of an effort to step up, because we cannot fund everything else and left detainees on the side. It's unacceptable. Also, it has real impacts on the detainees themselves, on their mental health, on delays in the proceedings, on unnecessary litigation. We are wasting a lot of resources by not wanting to invest in this one. So it is an important issue. unless, I mean, I hope I've made that clear. It is quite important, and it cannot be left on the side. It must be a priority. I think that, frankly, it should be part of the regular budget of the court. But failing that, states should be made to make mandatory contributions. There should be maybe a rotating system where, they're taking turns. But we need to have more involvement. We need to have more fun. It is unsustainable as it is. We keep looking for funds, waiting, and it cannot last like this. It has genuine impacts. I think I'm pretty much done here. Thank you.
Thank you, Marie-Helene. Of course, Jen, this would not be a problem if these proceedings didn't take so damn long. And you're going to tell us about that because, of course, Jennifer was counsel to Mr. Bagbo, who spent the best part of 9 years in custody only to be acquitted. Something I'm sure Jennifer won't mention at all.
Thank you, Peter. Yes, acquitted and not totally free, but that will be my conclusion, so spoiler alert. D'abord, je voudrais me joindre à mes confrères et consoeurs concernant les remerciements de la présence et du parrainage de l'ambassade de France et du Sénégal, et d'autant plus concernant la langue française. Je fais cette introduction en français. J'aurais aimé faire toute la présentation en français, en toute honnêteté, mais je passerai en anglais. Mais c'est quand même une des deux langues parce que c'est un accord que nous avons, vous avez gens. Et c'est une démocratie, je respecte la majorité. Mais c'est vrai qu'il y a deux langues de travail à la Cour, le français et l'anglais, et le français est en train de mourir. Et je pense que l'affaire Bagbo est l'exemple de ça. Nous avons obtenu le droit de répondre à un appel sur des brouillons de décision. Donc voilà, on en est à l'international concernant la langue. Bon, cette petite aparté faite, donc la discussion, je voudrais quand même poser les termes du débat en français avant de passer en anglais. On m'a demandé de parler aujourd'hui de la durée de la détention provisoire au regard des standards des droits de l'homme. Et évidemment, toute réflexion et toute discussion sur la procédure à la CPI et sa qualité devrait avoir comme point de départ les droits de la défense et plus particulièrement évidemment le principe cardinal de la présomption d'innocence. Alors c'est pour ça que je soulèverai des questions concrètes de l'application du statut de Rome concernant justement la détention, mais surtout ses manquements, et je proposerai des pistes de réflexion, de réforme du statut, de manière à aborder cette question peut-être de la détention de manière plus constructive. So I'll switch to English, and so as Peter mentioned, I will try to tackle the question of the length of trial and pre-trial and trial detention at the ICC from the perspective of human rights standards. As I just said in French, the cardinal principle that has to guide the parties, the participants, and the judges concerning any proceedings at the ICC is a presumption of innocence. So discussing the length of a procedure in an abstract matter doesn't make any sense because each case is different. What is necessary is that there is an adversarial debate at all the important phases. So only then the rights of the accused will be concretely guaranteed. This means, for example, the opportunity for the defense to actually have the time to familiarize with the case of the prosecution, to discuss it, and to present a defense. So this can take time, and it will be case-based. So this being said, in complex international cases, this time might vary. The problem is actually the detention during those proceedings. So that is the actual problem that we are facing here. As my colleagues mentioned, there has been, putting aside contempt cases, there has been no provisional release granted at the ICC since it exists. So why? What is the problem with the ICC system? Well, I identified 3 problems for tonight. The first problem is the concrete application of Article 58 conditions. Article 58 sets out a framework to justify detention. For example, there's a flight risk. In theory, the rule is that freedom is the principle and detention is the exception. Well, in practice, it's not quite how it works. It is literally the other way around. And why is that? Well, there are two, I'm not going to go into every condition of the Article 58 here, but I'm going to show you two problems with the concrete application. The first problem is that the judges have a tendency to consider that once they have made findings on one of those criteria, so for example the flight risk, they do need to reevaluate these findings in future decisions. That means that when you make a new request for provisional release, and in the Bagbo case this is 13 requests because we have asked for provisional release until the acquittal, well, there's a presumption actually that the condition of Article 58 will prevail. And this, what consequence does this have? This is a reversal of the burden of proof, because normally the prosecution has to prove that there is a flight risk. But if the judges consider that you are relitigating the question, then the burden of proof gets reversed. And this is actually what we argued in the Bagbo case several times. We said you have to evaluate the risk at the moment that we make the request. Every 120 days you make a new request. Well, at that moment you have to evaluate the flight risk. So that is the first problem, because the burden of proof is impossible for the defense to meet. Second problem is the standard of proof. Judges consider that in the debate about provisional release, they can take into account pretty much any evidence. So we're actually basing the fact to detain somebody on press articles, NGO reports. That's enough. In the Bagbo case, the pretrial chamber found, and I'm actually citing, that and this was concerning a UN report. So we know in the proceedings this would have very low value as evidence. The trial chamber found that bearing in mind the nature of the present exercise, so the present exercise being deciding about the freedom or not of an individual, and the principles applicable to factual findings, the chamber concludes that the group of experts' final report provides sufficiently detailed information which can be relied upon for the purpose of determining, in line with Article 58 of the statute, whether the arrest person appears necessary. So, a UN report is pretty much enough. And added to this, the appeals chamber said, and hold on, prosecution actually only has to show that there is a possibility of a realization of a risk. So if you put very low evidence with only having to prove the possibility of a risk, then there is a very low threshold to maintain somebody in detention. And the starting point is that detention is the exception. So it should be the other way around. So this is the first problem why we have so much detainees who stay detained and no provisional release at the ICC. The second problem with the system is that there is no explicit provision in the Rome Statute to take into account specific circumstances that have been recognized by human rights jurisprudence. For example, age can be a relevant factor. Health can be a relevant factor. The during of the proceedings can be a relevant factor. All these factors have been established in human rights jurisprudence, but it's nowhere to be found in the Rome Statute. And we actually managed in the Bagbo case to get some of the criteria as accepted by the chamber, and usually by the appeals chamber. The appeals chamber found that the health situation is relevant, that the age of the accused is relevant. And actually about the age, this is very interesting, because the pre-trial chamber found that the age was actually a reason to maintain Laurent Gbagbo in prison. So the older you get, the longer you stay in jail, no problem. Well, there we appealed obviously, and the appeals chamber found that that's pretty much the other way around. So, and the same concerning the length of the proceedings. The presiding judge in our case also found it should be taken into account. So my suggestion here is, and it's of course up for debate, is amending the Rome Statute and integrating those case law-based findings and integrating human rights in the Rome Statute, because Article 21 is not enough. The third problem with the system concerning provisional release is actually conditional release. Because even if the judges find that there are actual risks, like for example flight risk, the judges still have to look if there are other mitigating reasons that could mitigate those risks and see if the person can be released. So the case law, and actually it was in the Benda case, that the case law allows for the chambers to look at conditional release. But the phrasing is so vague that the judges have total discretional power. So they don't have to justify. They can just say, no, we don't think that anything would ever mitigate the risk, and that's it, no conditional release. The second obstacle is that the chambers consider that there should be a host state willing to accept the detainee, but also to take the responsibility for any conditions that the chamber would impose. And concretely, this is very complicated, these obstacles, because for a defense lawyer, it doesn't matter, and this is, I'm making the debate a little bit broader here, it doesn't matter if there are risks or no risks, because if it's provisional release as such or conditional release, in any case, if it is granted, your accused has to go somewhere, right? And that is your response, and the first responsibility comes to the defense counsel. So you have to negotiate with states, but are states open to that? That is the big question. They're usually open to receive even witnesses, and this was actually discussed in another side event organized by the IBA. So I will not dwell too much on this, but I think it's important to raise it. Because in this debate, we always say, yes, it's for the states to do things, and it's for the registry, but I want to stress here, I mean, this is an ICCBA event. As counsels, we have also responsibility here. In the Bagbo case, we anticipated this. In 2012, we started negotiating with Uganda, this is public knowledge now, with Belgium. So when there was an acquittal, we were able to get the acquitted person at that point to Belgium fast. But if there was a provisional release that had been granted, we could have acted fast. Because the problem here is usually not the registry and not the defense, it's the chamber. And then in their relationship with the state, and it's the states. We have two agreements at this point, Belgium and Argentina, who agreed to receive people for provisional release. Two agreements, and it's still on a case-by-case and voluntary basis. That is not enough. But we also have to take into account the judge's expectation and worries. I mean, if an accused is on trial, he cannot go to Argentina. I mean, the judge has said, well, that's way too far, and we can understand that. So actually in a very constructive debate that we had 2 days ago, and I'm happy to hear from the French representative that they are facilitators in cooperation today, because they were mentioned, French and Senegal, as potential champions for this. Because we have to take into account the language of the accused, the cultural background, and proximity to the court. I mean, in phases of pre-trial, for example, when you don't have hearings every day, you can imagine provisional release in another country, and that should be explored. But the truth is, when there is court, your client has to come and has to show up. So cooperation of states on this issue is fundamental, and that's why I'm actually stressing it here, because we need to promote this more and we need to get into context with states. And I truly believe that defense lawyers have a role to play here, because from experience, I know that it is possible. It is not easy, but it is possible. And actually, the registry knows how to play ball. In the Bagbo case, the judges said, well, you have to liaise registry and defense together to find a state that would agree and to discuss those conditions. And we worked very efficiently together. So I'm happy that for once I'm not saying, oh, we're criticizing the court, because there has been a great collaboration. So we can work on that, but we need also the states on board and to get off this bias of, oh my God, it is terrible to receive somebody who's been accused at the ICC. It is also a duty to make a provisional release a reality and not just a fiction. So we have the legal framework that's a problem, and the concrete framework that's a problem. I cannot finish my presentation today without saying a word about release after acquittals, because you would imagine that normally when a person is acquitted, he's free, goes home, and that's it. Well, not at the ICC. And it's not illegal in the ICC framework, because actually Article 83 allows this when there are exceptional circumstances. And now when we look at the jurisprudence, apparently it's even possible when we're not sure that there are exceptional circumstances, but okay. Well, that is maybe the problem, because, for example, the Kosovo Specialist Chambers, a similar provision to Article 83 was proposed, and they decided to not integrate it in the rules of procedure and evidence because it was judged unconstitutional. So maybe we can learn something about this. And the easiest situation, I think, here is and this is a proposition I make, is to amend the Rome Statute in a way that the ASP would consider to simply remove the whole Article 83. This is very easy. You remove an article and it's, oh yes, it's Article 1.3. I speak so fast. 81.3. Yes, thank you. No, you're right. Thanks. So remove it. Remove it as a whole, and it's easy. And it would not solve all the problems I've identified in my presentation, obviously, but it would show from the state a true commitment. Because, if you respect the fundamental freedoms of somebody who's been acquitted, something that should be uncontroversial, you're showing good faith for the future and for provisional releases to come. Thank you very much.
Well, I'm going to throw this out for questions in a little while. It seems from everything we've heard that there are some pretty obvious solutions to some of these problems. Just thinking out loud, if there are 5 detainees at Scheveningen and they could reasonably expect to see their family 3 times a year, then you're really only looking for 15 states to make a very, very small contribution of a few thousand euros, and that could be achieved. And all those states are here in this building this week, and I would have thought that it's incumbent upon somebody, probably a registrar or a president, to address them and say we're looking for 15 states to put up 5,000 euros each, and then that problem would be gone. That's just my thought. I wonder what the French representative thinks of that idea. But before we throw it out to questions, let's just get the rules clear. What I want from you are things that demand a response. I know you're all lawyers and you like to make speeches, but I don't want long speeches. You should be able to make a point and frame it in the form of a question in under a minute. If you don't do that, I'll cut you off. But having said that, I'll take questions now. Megan! What are you doing?
Are you sure? Defense friendly. Thank you very much for the excellent presentations and for really humanising something that we don't hear about very much. My questions are for Milan. What are I don't know whether you can answer this because of the confidentiality problem you've mentioned, but what are the sorts of things that the prosecution manages to bring to get these measures on contact imposed? Are they kind of additional to the arguments that underpin the original arrest warrant, or is it just enough that if you're suspected of a crime, therefore you shouldn't be able to speak to your family? And then second question, about the confidentiality, what is the reason when if you're on the defence side and you're happy for the decisions to be public, what's the reason for keeping them confidential, and have there been attempts made to have those restrictions on public access done away with which have failed? If you can speak about that, thank you.
I'll start with your second question, Megan. I don't know the reason. And as you know, me and Peter Robinson attempted on many occasions to make these proceedings public. We complained about the ex parte, we complained about the confidentiality, we filed a motion asking the Chamber to reevaluate and reassess a number of ex parte proceedings, 76 in total. We try as much as we can to make public filings. That's why, as Marie-Hélène mentioned, we filed a public motion regarding family visits, I believe 2 or 3 weeks ago before the presidency. We want them to be public. Mr. Yekatom has no problem having those decisions or those motions being made public, but confidentiality became the rule at the ICC, and it's part of the problem, and it's also part of the problem for councils, because we cannot share among each other arguments and decisions. Some colleagues are saying, I wish I could help you because I have the perfect quote, but unfortunately chambers have refused to lift confidentiality. So I don't know the answer to the question, to question number 2. For question number 1, I'll try to be as general as I can, bearing in mind the very few public decisions I read on the matter. The arguments the prosecution are bringing forward are not, they're not merely based on the warrant of arrest, because, as I said, some of the detainees can face contact restrictions before they even arrive at the detention center, so the only tool you have is the warrant of arrest. But the majority of the time, the prosecution will use arguments, situations that are outside the control of the detainee. So the volatile situation in the country, vulnerability of witnesses, political parties being present in the country, alleged supporters of the suspect or the accused, a co-detainee at the detention center. All these factors are outside the control. It's not as if the chamber or the prosecution were saying, you know what, you used coded language last week on your phone communications. We are worried that you're trying to hamper the investigation or harm a witness, so we will now monitor your conversation. It's not about, in some cases it might be, but most of the time, and recently, it's about what's happening in the country, which is something you'll never be able to change. In some cases, and I know this will sound surprising, we do not have access to the original request that brought the chamber to agree to imposing contact restrictions. You might have heard it during the confirmation hearing of Mr. Yekatom. We still do not have access to the application for warrant of arrest.
Beth.
I'll try to make this a question because I want to play by the rules.
Microphone.
Okay, I'll try to make this a question because I want to play by the rules. Thank you to all the speakers and to those of you who organized this. My question is this: is the situation, anyone can answer this, but is the situation of acquittal with conditions in the, for example, Bagbo Blake Boutte case, does anyone think this is moving in a slippery slope towards a situation which still exists in Arusha, where there are 8, 9, 10 people in the safe house, including somebody who's been there since 2004, all of whom were acquitted? Just your perspective on where it's going.
Well, I think it's not exactly the same question because in our case, it's the court that doesn't want the freedom to be complete. The judge has said, well, we're going to limit the freedom of Laurent Gbagbo and Charles Goudet. It's literally the other way around. It's states that are not willing to receive the people that have been acquitted. So, I mean, they're both slippery slopes, but they're not for the same reasons. I mean, we have a state, and we have several states, or would have you to get Laurent Gbagbo if he'd be totally free to do and to travel and to do everything he could. So it's not the same framework, I would say.
Kater. Xavier Jean.
Same. Good evening. Xavier Jean Keita, Principal Counsel of OPCD Defense Office in ICC. I wanted first to thank all the panelists and of course Friends of Senegal for hosting this event. It's good to have practitioners and and going directly to the points, because you know what you are talking about, and I'm happy. Here we have Marc Dubuisson, and I've seen Paddy with the head of detention, and I think that it will be good to have some exchanges with them. I wanted to say that being in this code for almost 13 years, we have to give credit to the full registrar to have managed to have a minimum of funds for family visits. It's not to complement the registrar used to fight for several things against all of them, but nicely. I mean that it's not normal when you have a right to have this right depending on voluntary contribution. So that said, my proposal will be radical. I think we have to stop this trust fund and to move it out, because I have seen the reaction of some states when I discuss with them about family visits being in the regular budget. They say, oh, you have the solution, Keita. You have now a trust fund for family visits. So if we don't fight for a state to move this institution or body out, that will remain an excuse for them not to contribute. The main problem for me, I think, it's a change of culture inside the ICC and outside, together with the states. Why? Because they still consider that our clients, suspects and accused, they are just criminal. It's more, it's easier for those states to have agreement. You are not quoting this type of agreement, but easily they welcome some dirty hand witnesses in some agreement with the ICC, and they are not ready to sign for agreement concerning provisional release, acquittals, post-acquittals, etc. We have to change the culture. 1.5 years ago, almost 2 years, my office have drafted a memorandum for having among the state party a focal point for fair trial. It was endorsed by ICCBA. It was co-drafted by the two OPCs, victim and defense, showing that fair trial is not only a matter for defense but for all. And it was submitted to Fatou Bensouda, and she said, I totally agree, but I cannot sign, but I will try to advocate for you. This was in early 2000, I think January or February 2018, and states asked our office to send it in the 2 working languages. That was done. Till now, I cannot have any response about that. Having a fair trial focal point in our plan, this question of restriction, family visits, cooperation, and even privilege and immunity for counsel, this was in the package. To have a focal point, not to talk every time about that, but just to be the one to be contacted and to submit to the state party our concern. So this have been denied. So my second proposal is, you should, ICCBA for instance, and those who can help us for that, to relaunch or to fight for states to consider this proposal of focal point and to move out this trust fund for family visit. These are my two proposals, concrete.
Well, it just shows I'm not a man of my word. That was 4.5 minutes and I didn't stop you, but you are the principal counsel. Anybody else?
Sorry, I don't want to keep it on this end of the table. I'll be as fast as possible to say thank you, ladies, for your intervention. Oftentimes I feel like when you're talking about delay of trial, it seems like it's often blamed on the defense for dragging out the proceedings. Are there concrete measures that you ladies have seen in the trials that you would like to shorten to make it, if we can't fix the situation in detention, how do we make the trial shorter?
I'm going to have a go at that one.
Ladies.
I was at an event recently where, strangely enough, somebody from the OTP spoke, and he broke down each of the trials that had taken place at the ICC. It won't surprise you to hear that the worst one was Bemba. 4 years of trial, 330 days of sitting. That's 82 days a year. In Lubanga, I think the trial chamber sat for between a third and a half of the available time. The best one is Katanga, just over half. And the reasons for this intermittent hearing of the evidence is almost never the responsibility of the defence. It's quite often the responsibility of the prosecution who can't get witnesses there on time. And it's always been my view, because that's the system I'm familiar with back home, that sort of delay being attributable to the prosecution automatically raises a change of circumstances which should entitle you to provisional release. The other provision that most domestic jurisdictions have, and which I think it's high time came to international criminal law, is custody time limits. You shouldn't be allowed, and again, Bemba's a great example of this, to arrest somebody and then spend over a year confirming the charges against them. That's quite wrong. You should be in a position within the statutory limits, which I think is 60 days, to confirm the charges once you've had somebody arrested. And those are the two changes I would like to see made. I would like to see better jurisprudence on how delay in proceedings gives rise to a right to provisional release, and certainly that charges need to be crystallised within an appropriate period after arrest. So that's my 2 penneth on that one.
I would like to respond to that actually, because you're laughing because you know that I have maybe a different view of this. First of all, I think that we're doing better. Trials are going faster. I mean, we were sitting pretty much all the time, and we had in less than 2 years 82 witnesses, which is almost triple of any other case we had at the ICC. I think that reproaching to the defense to be the one that loses time. I mean, we just got an acquittal after no case answered, so we just won a lot of time. No defense case, no appeals, and everything that goes with that. And when we were actually fighting for the no case answer, everybody was reproaching us that we're probably wasting our time. So it goes me back to my introduction. I was to say that the cardinal point as a lawyer is the rights of the defense, and you have to use every tool at your disposal. In international criminal law that actually takes time. And I know a lot of people say that the confirmation of charges hearing is a problem. I don't believe that at all. It's been inspired by the French system, so maybe it's more familiar to civil law lawyers. But it is a real opportunity actually to question the case of the prosecution. And we saw it in the Backwell case. We made a mini trial out of the confirmation of charges hearing, and we got an adjournment. And the judges played a little bit with the law because it should have been an information. And this was a warning. I mean, we didn't get a no case to answer just like that. We told them in the beginning of the case, this case is weak, and we showed you this. Because I know that you don't call the witness, it's not the same dynamic, but you can still question if there is no corroboration, if it's all anonymous hearsay, for example, if it's a lot of NGO reports. Those are evidence that are not good, and it's usually the basis of the case of the prosecution. So this phase is, if in my experience, and I truly believe this, and I'm fighting for this because I would like to maybe train more common law lawyers to understand how this is an essential tool. Because if the judges didn't play with the law at that point, we we would already be home, and that's why we do have a no case to answer now result. So it doesn't mean that it's going to work every time, but if you take a right start with this confirmation of charges hearing, I think it can actually gain a lot of time, and that's why it was created, actually. But if we got practitioners who are not used to a tool that comes from a civil law system, then it's lost, unfortunately. And I know I'm not making friends by saying this, but it is based on experience, and the results are there. So, and not only in this case, I mean, we played with this in other cases as well, and it has always been successful. So I would actually like to convince the colleagues that this is a good thing and that we can do more with it. And the problem is this: what I started my presentation. It's the provisional release. If your client is in a situation where he is outside, even with conditional release, and you can do your work. I mean, another example is you said the defense is criticized. We were the first one to raise the fitness to stand trial, and we raised it in the confirmation of charges hearing and at the beginning of trial. We lose time, but this is a basic right of the client. And there's going to be compensation at the end. If we don't do it, how do we ask compensation? If we don't ask for provisional release, how do we ask for compensation? How do we put the court in front of their responsibility? So we need to use the tools, and it takes time, unfortunately.
Sorry, I also want to say something on this. And I don't fully agree with Jennifer, but we're allowed different opinions. I think that one of the biggest problems is that there are OTPs requesting surrender of individuals at a time when they are not trial ready. They're not nowhere near being trial ready. For my client, he was surrendered late March 2018. He had initial appearance, and the first date for the confirmation hearing was supposed to be September 2018. It took the prosecution over 3 months to just start the disclosure process. So for 3 months, we had no evidence. So clearly, we had to go to an extension. Prosecution requested a first extension. It was substantially extended, and it was supposed to take place in May 2019. Approaching that date, prosecution said, no, still not ready. I need more time. So they asked to push it back again. And in the end, we held our confirmation hearing in July of this year. That was already 15 months after he was arrested and surrendered to the court. Now, a month of submissions, written submissions, then 2 months, 60 days to give the decision. We had the confirmation decision 30 September, 18 months after surrender. So that's 18 months being just a suspect and being under very strict monitoring measures. That's an awfully long time when you're presumed innocent and you're not even charged with any crimes at that stage. Now, we're heading towards trial. The trial chamber indicated in a public filing a couple weeks ago that they are looking for them to start trial before the summer recess. That would be quick. That would be 6 months. I would not put any money on that date. I think it will not stand, and that's extremely unfortunate because we're going on 2 years at the ICC now in a couple months. 3 years if you count the time that he was detained rally before surrender, and trial has not started. I think it's extremely inefficient, and I understand that there's no police for the ACC, so they take an opportunity to get someone. If they have the opportunity, they just go with it. But this is absolutely against the right of the detained person, of the suspect, and of the eventual accused. It's prolonging proceedings, it's prolonging detention, and frankly, it's absolutely unfair. And the pre-trial process is way too long for what it gives in the end. And frankly, and again, my colleague is French, I'm not, I would tend to go back to the ICTR system where when the person arrives, he's already indicted and we can start. I think that would go a long way into preserving their rights against unfair detention.
Duff? Yeah. Just to react on this, I've blogged about this, so it's not just a backdoor ganging up. I've had those opinions. No, I just want to make it clear. We share the same opinions on this.
We're not ganging up.
I think this ICTY, the two things. One is, again, the length of proceedings is a very theoretical thing, and we can't confuse detention and length of proceedings. It becomes unfair when the person's in jail. Those trials take a while, the evidence is huge, the defense teams are small, the prosecution teams are big. It takes a long time to go through the evidence, cross-reference it, analyze it, and it doesn't take 5 minutes. And to come back to this ICTY thing, tell that to the two in Kenya whose charges were not confirmed. We didn't go to trial for 10 years based on the rubber stamp indictment. To Ambarushimana, to Abu Garda. So I think we have a very bad view of the confirmation of charges. And maybe if there had been a confirmation of charges at the ICTY, the ICTR cases would not have lasted 15 years. Maybe out of the number of acquittals at the ICTR, maybe X percentage of them would not have even gone to trial because there would have been a confirmation. So I'm not defending the system. I say we generally have a very unfair view of it, which should take into account the benefits it has. And again, in Bagbo, the fact that we were able to challenge the evidence, it laid the groundwork down for the no case to answer. So, not saying it's a perfect system, but I say that everybody calling for it to be just removed from the ICC is premature anyway, and requires more reflection.
Never told me that.
Beth, again.
I'm just sitting here listening. I have comments on this point, which is I'm sitting here listening, and I'm just sitting here saying there's no bail proceeding here. There's nothing. We're not even talking about the judicial releases after the fact. And in terms of, I don't know about lots of international jurisdictions, but your comments on that, because that also affects, what happens with, undue delay, and is it undue, et cetera, But your comments on the issue of no bail proceedings.
On theory, I would love it. And I know as a French lawyer, I'm always considered as being anti-common law, but I'm actually very pro-common law, and my French colleagues hate me for it. So, except the confirmation of charges hearing, I'm pretty much for cross-examination and everything. But the thing is, we're dealing with a majority of indigent accused. So where do we get the bail money from in the first place? Because most of them are indigent, and that is a practical problem I think we're facing.
I'm raising it, I'm not raising it preliminary as a practical problem, but I think that's a point, and that's a valid comment. But the concept there is, has anyone who's practiced here ever heard of a bail proceeding? Not all, a few are not indigent, they become indigent afterwards, but any kind of bail proceeding, either based on money or community sources or whatever. I've never heard of it here, and it's outrageous, right? You practice in criminal court in some jurisdictions is always a bail proceeding, even though people can't afford it necessarily, they're indigent clients. But there's no way out early here. So of course you have more delay.
I think the consensus is that you're right. Anybody else?
Anybody else?
Please, anybody else? Yes. Please introduce yourself.
Good evening. I am Aditi Pradhan with the International Bar Association. I hope you will indulge me because I want to make a comment and ask you a question.
I'm starting the clock.
The comment is on the event that happened yesterday evening on the Trust Fund for Family Visits. Today at the plenary session of cooperation, the registrar and the ambassador for the Netherlands spoke and recommended states to contribute to the fund, as also did Kate, who is the program director for IBA. And my question is, to your introductory remarks, how are you looking to engage with the review process come February and March when they ask for consultations?
I'd love to be invited, but as I said at the opening, tapping the resources that there are in this room, and they are considerable. On this table there is, scores of years of experience of conducting cases in international criminal courts. And I don't want to overstate this, but I do find it mildly offensive that nobody has thought to say, well, there's an institution that's just asked for a resolution to be passed acknowledging it, as the Bar Association to the court, but we don't want to hear from them. And in fact, there's nobody on the list of independent experts with any experience of the defence. I'm not entirely sure what I can do to be part of that. We can certainly lobby and submit documents to the appropriate focal point within the court. I would hope there might be some reconsideration of the list of people who are consulted in the revision process. That's all I can say. Unless you've got any advice, you're a little more mature organisation than we are.
I don't think I want to be in that position to offer advice right now. But yeah, the feeling that I get from the discussions that the states have been having is that they are looking to have as wide as consultations as possible. And I can't speak for the experts and what their process will be, but surely councils should be able to present opinions. And I think I think IBA would be willing to support that external councils can participate in the review process.
Well, certainly, I mean, the impression I've had from my personal contacts with the registrar and the president of the Assembly of States Parties is that they're not closed to council making a contribution. But, you know, Boris Johnson, you know, said we'd save lots of money on the NHS. And never trust Brits. Yes. Anybody else? Would you like to say anything else?
Well, I'm quite convinced that all the stakeholders should be part of the work of the experts. So I'm quite convinced that the council won't be forgotten. I hope they won't be forgotten. And maybe as states parties we can give the experts a signal at which, at least a wish, because they are independent. So now it's on their hands, but it's part of the deal. All the stakeholders should be heard. So I share your view, and I hope that the council will be heard. I just wanted to say a word of the condition of detentions, because I had the great opportunity to visit the detainee center. In fact, it's I think one of the first things I asked for when I started to work for the ICC, and I would like to thank. I'm sorry, Sarah, I forgot your name, but I know that thanks to you I could visit it, and thanks to Mr. De Buisson. And just to say that, of course, the condition of the call, I can make, of course, any comments because it's the court's decision. But just to say that the conditions of detention are, quite good to my sense. And just to thank for that the great job that is done there. Thank you.
Thank you. Well, I just want to reiterate our gratitude to France and Senegal and to Dominic and everybody who's helped put this on today. And to thank you all for coming and for the thoughtful contributions you've made. It's been a very lively debate, a very intellectual one in my view, and I think, well, I hope it paves the way to concrete changes that will ameliorate some of the problems that have been highlighted here this evening. But once again, thanks Mylène, Marie-Helene, Jennifer, for your contributions. They were truly stellar.